Hello and welcome. I'm Amritan Rai and you're watching Law of the Land on Raj Sabha TV. Today we bring to you a Supreme Court judgment on death and remission sentences which does not offer a solution but records the dilemma of the judiciary on serious issues like death sentences and life imprisonment sentences. To discuss the issue, I have with me Justice Mukul Mudgal, former Chief Justice Punjab and Haryana High Court, and Mr. KTS Tulsi, Senior Advocate in the Supreme Court. Now for the headlines. The Supreme Court protests the arbitrary grant of death and life sentences. It recommends fresh look at the sentencing of capital offences. And directs the government to obtain opinion of presiding judge before granting remission. The Supreme Court has protested the arbitrary manner in which death sentences and life sentences are being granted by courts. The judgment says that courts have not taken the sentencing process as seriously as it should, with the result that capital offence has become judge-centric sentencing. The court reduced the sentence of a convict to life sentence from death while recommending the need of a fresh look at the sentencing of capital offences.
Referring to the judgment of a 5-judge constitution bench, which for the first time devised the benchmark of rarest of the rare for grant of death sentence, a 2-judge bench of the Supreme Court in its recent judgment says that the constitution bench of the Supreme Court has not encouraged standardization and categorization of crimes, and even otherwise, it is not possible to standardize and categorize all crimes. The judgment reasons that some of the courts choose to rely on the situation in which capital offence was committed to grant death sentence, whereas some go by the condition of the criminal to grant life sentence in place of death. This arbitrariness by the judges has been pointed out by the bar many a times.
Some of the judges go by the 5 principles laid down by the Machi Singh. Some of the judges go by, no, this is not a standardization, and like the Bachchan Singh says, that it cannot be standardized. So therefore, the judge goes by his own opinion. So there is definitely uncertainty. There definitely it is entirely dependent on the judge whether he goes by both. Though Machi Singh has been more or less been the guideline. Some judges go purely by that as if these are the directions. Some say no, these are the guidelines, these are not applicable to this case. So therefore, I will go by my own opinion, not bound by this. So there is definitely a conflict as of now.
The 2-judge bench of the Supreme Court, comprising Justice K.S. Radhakrishnan and Justice Madam B. Lokor, reasoned that the criminal law states that the punishment of imprisonment for life should normally be imposed, but a sentence of death could be imposed as an exception. If a sentence of death is to be awarded, special reasons need to be recorded. This, according to the judgment, left a lot of discretion in the hands of judges. Based on this, certain indicative parameters evolved in which some judges relied on the circumstances in which the crime was committed to grant or deny death sentence. These are if the murder has been committed with previous planning or involves extreme brutality, if the murder involves exceptional depravity, if the murder is of a member of any of the armed forces of the Union or of the member of any police force or of any public servant while on duty. Similarly, some judges relied on the condition in which the criminal was to uphold or deny death sentence or life imprisonment. Some of the indicative parameters are that the offence was committed under the influence of extreme mental or emotional disturbance, the age of the accused. If the accused is young or old, he shall not be sentenced to death. The probability that the accused will constitute a continuing threat to society, the probability that the accused can be reformed, that the accused acted under the duress or domination of another person, that the condition of the accused showed that he was mentally defective.
There is no uniform sentencing policy. The Constitution Bench has deliberately refrained from standardizing that procedure. This judgment says that maybe it is time to relook at standardization. You have to look both at the circumstances of the crime as well as the circumstances of the criminal.
the death convict had appealed to the Supreme Court, pleading for a reduction in the sentence. Both the trial and the High Court had held that the crime fell within the rarest of the rare category and had granted death sentence. But the Apex Court set aside the decision of the High Court and reduced the sentence to life. The judgment reflects the dilemma of judges who sits on the decisions relating to severe curtailment of life and death. On one hand, they have to decide who lives or dies. On the other hand, there is no clear-cut standard or policy which can help them to make such decisions. With camera person Vijay, Aruna Thakur, Rajya Sabha TV.
The judgment says that it does not endorse the approach of aggravating and mitigating circumstances, as was ruled in an earlier judgment popularly known as Bachchan Singh judgment. However, the court goes on to say this approach has been adopted in several decisions. This needs a fresh look, as there is little or no uniformity in the application of this approach. Sir, you have been on both sides of the coin. One side, you were part of Bachchan Singh while the case was being argued in the Supreme Court, in the Constitution bench. Yes. On the second side, you were part of granting decisions or death or life, whatever, on the judiciary side, sir. Now, as of now, how do you see the judgment as a whole? Do you see it as reflecting the actual dilemma of the judiciary?
Can I start by Bachchan Singh's case?
Please do so, sir.
You see, when the case was being argued by my senior, Dr. Chitle, I was assisting him. My senior felt after time that 4 judges were against us. We were challenging the validity of the capital punishment, and that one of the judges, Justice Bhagwati, was in our favor. So he asked me to go through all the judgments where death sentence was commuted to life and write out the reasoning behind each of such judgments. Right. Frankly, the written submission which Dr. Chitle handed over to the court was a summation of these judgments, which have now been described as the test for rarest and rare cases. Right. The division bench of the Supreme Court now, which has pronounced Justice Lokur's judgment, is very clear, and it has correctly analyzed that Bachchan Singh was not the law laid down by the Supreme Court, but it was that these are the circumstances which are relevant and should be considered. It did not rule out other circumstances. But several judgments of the Supreme Court have taken that these are the tests laid down in Bachchan Singh's case, and therefore it's a very incisive analysis of Bachchan Singh's case, the judgment of Sangeet by Justice Lokur. Right. And I would also like to add that this is a visionary judgment, and this is how a constitution should be interpreted, and at the highest court. And it looks at the most important part of the judgment is it gives weightage both to the crime and the criminal. And the pendulum having swung a little towards, or rather a lot towards the crime, has been sought to be brought back as a balancing factor.
Right. Very honest admission, sir. Very, very honest admission by the judiciary. Probably first of its kind. Now, the dilemma with the judiciary. The standardization can't be explored. Categorization can't be explored. That road has been blocked by the Constitution bench. And you can't go any further than that. Second, now the decision on the judges to either focus on the criminality, or the criminal, or the circumstances of crime. Aggravating, mitigating. The decision is very difficult. Most of the judgment goes on to list out several judgments where some judges have just gone on the aggravating circumstances, some have gone on the mitigating circumstances. Do you really think that the discretionary powers with the judge, as it is now, should be allowed to continue, or there should be standardization and categorization?
And this is a serious problem. After all, we're dealing with life or extinguishing life. And it can't be like a lottery. And according to the report of the Law Commission relies on the work of a scholar who demonstrates by looking into the details of about 50 cases and proves that if that very case had gone to another bench, it would not have been awarded, he wouldn't have been awarded a death sentence. Yes. And if the person who is not awarded death sentence and escapes death sentence only because his matter was before a different bench. So the Law Commission had recommended, in fact, for the purpose of confirmation of death sentence wherever the matter comes to the Supreme Court, it should be decided by a bench of 5 judges. And there should be a rule of unanimity. Unanimity amongst all 5 judges. If one judge differs, there should be no death sentence. That means that there is an element of doubt about the culpability of an individual. And if one judge of the Supreme Court out of 3 says that no, I acquit the accused, yet the 2 have gone ahead in some cases and awarded death sentence. Now that can't, according to me, we have to be extremely careful while awarding death sentence, that also at the level of the Supreme Court. After the Supreme Court, only God can save them if there are any mistakes. And why does the Supreme Court not consult the psychiatrists, not consult the jail officials' report? What has been his behavior? After all, he has been in the prison for 8, 10, 15 years. Is he a reformed individual or not? So for penalty, for deciding, for choosing between different punishments, different options of punishments that are available to the judges, we must consult experts in the field. It's not enough for a judge to go by his own whim of fancy. It can't be like the Chancellor's foot.
Sir, that's all right, sir. But it's a very difficult balancing act for the judge to, and they are tempted to either fall on the criminal aspect or go into the crime aspect.
That part is correct. When somebody's life is involved, a dilemma is always there. But let me tell you, the judgments will always be judge-centric. I mean, you cannot rule it out. There are some judges who are inherently opposed to death sentence. They will always find some reason
mitigating
to reduce. Some circumstance can be lashed upon. There are judges who are inherently very, very
favorable towards death sentence.
Not favorable. Some have been fond. Now, it is those judges who will always try to give capital punishment.
Aggravated.
There is an instance of Supreme Court where one judge acquitted the accused and the other 2 judges imposed death sentence, which was a very surprising decision, to say the least. When one of the judges of the Supreme Court has been convinced that the person was innocent or not guilty, then the other 2 judges should have at least reduced the sentence to life. I mean, that is.
But this discretion that is there with the judiciary, do you think the standardization and categorization can at least be, thought of by the policymakers? Is it possible?
I would not tend to leave it to the policymakers, that is the Parliament, for this reason. The subject is so vast, the circumstances could be so very different in each of the cases, that I don't think laying down written law in this is the right thing. Maybe the Supreme Court can evolve certain more principles. I'm not saying the Bachchan Singh principles are wrong. They should also be considered. But as Justice Lokur has given, that aggravating circumstances relate to the crime, whereas mitigating circumstances relate to the criminal. Now, this is a very, very fascinating analysis. It has not been done before. It's a novel, path-breaking finding in paragraph 2 of the conclusions. And I really, it is advancing our penology, and he has already said in the judgment that this law is evolving. I hope and trust that he continues to be part of this evolution of penology into a more rational and more humane penology.
It's time for us to head into a break. When we come back, we will talk about the directions to the government on steps to be taken before grant of remission. Welcome back. The Supreme Court, in the same judgment, held that the government has the right to grant remission but found it arbitrary. The court directed that before exercising the power of remission, the government must obtain the opinion of the presiding judge of the convicting or confirming court.
The Supreme Court were concerned in the manner in which remission were granted by the governments. According to the National Crime Record Bureau, under trials and detainees released during the year 2011 revealed that the total number of convicts who were granted pardon was 17, and under the head of other releases, a total number of 12,400 were released. The total number of under trial release were 29,517, and the total number of detainees released were 340.
Like recently, with this Koshorilal case which I have told you, when this person was given 7 such sentences, 3 death sentences were even confirmed by the High Court, and they were converted to life imprisonment by the Supreme Court. He was ordered by the government to be released. He had only spent 15 years in the jail and was ordered by the government to be released, and he was about to be released. The Lieutenant Governor, when the hue and cry was made, Lieutenant Governor said, I am not even informed that he has been given 3 death sentences, and the trial court has given 7 death sentences. No, this is the casual approach which the government deals with.
The Apex Court held that the convict undergoing life imprisonment should remain in custody till the end of his life, subject to any remission granted by the appropriate government. But it clarified that even under remission, the government cannot reduce the period of sentence less than 14 years of a life convict. The court also pointed the need to put an end to the practice of mass release of the convicts by various state governments on festive occasions, as it reflects arbitrariness. The court directed that each release requires a case-by-case scrutiny, and the government must obtain the opinion of the presiding judge with reasons.
Section 433 capital A of the CRPC also says that you can have a minimum, that remission in any case cannot be less than 14 years. So this is how the standard 14-year norm has evolved. Now they have said that somehow governments have evolved a 20-year span for a life sentence, which they say is nowhere available in any statute or the delegated legislation. So that 20-year artificial lifespan which has been evolved is not there anywhere. So therefore that needs to be debunked.
The Supreme Court in the judgment clarified that the life sentence was to last for the entire life of the convict, and that the convict does not have an inherent right to remission after serving a particular fraction of the sentence. The judgment clearly says that the government has the right to remission, but it raises objection on its arbitrary use. With camera person Vijay, Aruna Thakur, Rajya Sabha TV.
The court has said that in case of a convict undergoing life imprisonment, he will be in custody for an intermediate period. Therefore, remission earned by or awarded to such a life convict are only notional. There are some judges who are known for to favor death sentences. Yes. There are some judges who favor life imprisonment over death sentences. So these two categories are very clear and it's pronounced. People know. So that is where I come and join with you when you said, if a person X who's been given death sentence happens to go to a judge who is favoring death sentence, he's a sure shot death.
That's right. That's exactly what the Law Commission said. That to reduce the element of subjectivity in a matter of life and death, where there is going to be a judicial death, to reduce that element of subjectivity, have a larger bench of 5 judges. A smaller bench than 5 judges will not award death sentence. Let the Supreme Court rules be amended. And the second was that there has to be unanimity amongst 5.
Now that's very, what the judge is actually, the judgment is actually trying to say is notional. How can you?
I think probably I would understand the judgment to mean that they are notional till the issue arises for consideration. At the time of considerations, the remission certainly can be considered. You see, till the time comes for consideration of premature release, it is called in law, of that because the life sentence cannot be quantified.
Yes,
it's called premature release.
Right.
Now, when it comes, the judgment is absolutely right in saying it is notional, but it does not remain notional when his premature release is being considered. At that time, his jail conduct, his behavior, his propensity for reform, all these
Factors
are to be considered and should be considered.
My colleague Aruna Thakur spoke to Justice Abdul Karim and tried to get his point of view.
The judgment raised the issue of inconsistency in using the principle of rarest of the rare. So what will be your opinion on this?
What the court has noticed it, that recently, in spite of the judgment of the Constitution Bench of the Supreme Court, in Bachchan Singh case, the death sentence has become judge-centric.
What, according to you, the life imprisonment should be? Because the court in this judgment held that the life imprisonment should be till the end of the life.
Yes, see, in fact, that is what with the Indian Penal Code says. Life means till the termination of the life. How can, when this is there, now any interpretation given to that, and then this 20 years has been assessed under some Karnataka rules or some state rules. But that is not what the IPC says.
How will you conclude the judgment?
I mean, if I can quote an Urdu couplet, सच बात मान लीजिए, चेहरे पे धूल है, इल्जाम आईने पे लगाना फजूल है. So therefore the Supreme Court has said that yes, our judgments have become, on sentencing part, have become this judge-centric. This can't be. It is, if this goes on, then we will find in one day, one bench holding it to be a death penalty, that very day, the other bench, because the matters are heard, holding it to be a life imprisonment. So it has just become a lethal lottery.
The judgment says that in the sentencing process, both the crime and the criminal are equally important. But the judiciary has not taken the sentencing process as seriously as it should be, with the result that in capital offences, it has become judge-centric sentencing rather than principled sentencing. So on this issue, sir, whatever the judgment have said, one thought or one idea that comes to your mind, which I think you should, which you would like to share with our viewers.
My view is, in judging the circumstances of the criminal, there should be a psychological and sociological study done by an NGO associated with some government authority also, so that that report can be presented to the authority considering premature release.
But on the judgment as a whole,
it's a very welcome step, and it will give an opportunity for the court to review the functioning of the rarest or the rare test, to what extent it has fulfilled the purpose, the balance sheet that was supposed to be drawn of the aggravating and the extenuating circumstances. But that balance sheet also is so subjective and so subjectively applied. So I really welcome this step and congratulate the judges.
thank you, sir, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the YouTube. We'll be back with a new issue and a new episode. Keep watching Raj Sabha TV.